have the effect that we're saying it is going to have. That is one. So maybe when you're responding, you could be able to just give us some context as to why there is this speed in which this bill has been passed the way that it has. Second, you reference the article from the...
Has it been passed?
No, sorry. Why this bill is essentially going to be...
It's being rushed.
Yes, it's being rushed through Parliament, and from what we hear, it will be passed. But maybe this is not the right platform for any conjecture. We shall wait for that to actually happen at that point. But we're seeing it. I think today there was I don't know whether it was a typo, seeing, I think, first reading, yes, a second and third reading. I'm not sure whether that actually happened. And yet we're told that there's a committee meeting that is going to happen on Friday to be able to listen to views. So is all of that, just for show, or is it actually going to take into consideration of all of these industries? So, but let me first park that there. Now, you also mentioned, and I did read the article from the Land Attorney General. It was very, very well written. But the challenge I found with the Land Attorney General's analysis, which I'll also share with you, since those are views that you also accept or you go by, is that on one hand, you have framed what this bill should do. But on the other hand, how your drafters have prepared it, they have essentially gone beyond what your mandate is. And what you're telling us to do is you have come into this room, with a grenade, and you're telling us that this grenade is only for one person, this grenade is only for Ellison there, and everyone else who's in this room, you don't have to worry, but yet you have a grenade. Ellison, I'm sorry, this is not to say that if a grenade comes, but
no, it's okay.
I am using that analogy just to show you that for us who are interpreting or reading these provisions, you're carrying a grenade and telling us not to panic. And like I said, so I now want to answer the question that you've asked in regards to how perhaps this bill could have been drafted. You reference several other laws, and you're saying that this law is the same as them. I disagree. If I read the Foreign Interference Countermeasures Act of Singapore in 2021, I would say in terms of governance, perhaps we would be similar, would look at how the Singaporeans do their thing. But in that act, for them, they actually, when they're defining foreigner, they don't miss words. They say clearly it means an individual who is not a citizen of Singapore. So why not have, if we're saying that we want to have best practice, or we want to protect sovereignty the way that other countries are doing it, why not be clear and define a foreigner to be someone who is not a citizen of Uganda without having to create all of these other categories? Because we must understand that once a law is passed, and that's why at the beginning I mentioned that if a law is uncertain, what it does is it causes issues, or that uncertainty makes it difficult for anyone to operate in a meaningful way or to believe that they are safe. Number two, again, looking at that law, this Foreign Interference Countermeasures Act of Singapore, it also introduces or defines what it calls a foreign government-related individual, which means an individual who is related to a foreign principal, that is a foreign government, foreign political organization, foreign public enterprise in either both of the following ways: an individual who is accustomed or under an obligation to engage in conduct in accordance with the directions or wishes of a foreign government, or the foreign government, foreign political organization, or foreign public enterprise is in a position to exercise in any way total or substantial control over the individual. Yeah. What I am saying is that there is best practice as to how this law should look like. And ultimately, why not craft the objective to be clear that it is the protection against covert foreign influence, unlawful interference in elections, undisclosed political financing, espionage, and incitement. If you're looking at foreign control of strategic institutions and what you're talking about, that policy capture, be clear with that in such a way that me, a policy lawyer, and other think tanks and other people that are interested in policy do not have to fear that as a result of us introducing or proposing to government policies that we feel will be able to help industries or help the people of Uganda, that we are criminals. If I look at clause 10 of of this bill, a person shall not engage in any activity, solicit, obtain, or receive any assistance from a foreigner, or organize a meeting or any function with the aim of promoting foreign policy in Uganda that has not been adopted by policy as government policy. Mr. Barata. Yes. What that essentially means is that we have been hosting symposiums as KTA for the last 9 years. And in these symposiums, what we've been doing is showing government that, look, the private sector is with you. When you're regulating, work with them in knowing that if you pass a mobile money tax that is going to have an adverse effect on financial inclusion, be mindful of the consequences of that particular law. And through that, we have had very meaningful engagements and policy changes that have happened as a result of these particular engagements. But what this clause is saying is that the only way I can be able to organize that symposium is if I first get approval from cabinet or I first share those policy views with them. That means we cannot be able to engage in spaces like these when it comes to anything to do with policy. So what I'm saying is that it could have been drafted better by one, defining the mischief clearly. If you're looking at targeting covert interference, controlling or deceptive foreign influence, or any foreign-linked activity, define it so. But when you add or have these provisions that are broad and vague the way that they are, like I say, they cause uncertainty. So the first one is it should define the mischief clearly, and I like the question directly that was asked directly, what is this bill trying to address? Number two, which we have also, I have already introduced, the correct definition of a foreigner. We have already been talking about identity and what it means to have identity. I will read again from that book where Asmani at page 92 is saying that identity is not a privilege for the state to bestow or revoke. We should not be having debates about whether someone is a citizen or not, specifically if the Constitution, the supreme and cardinal law of our country, already defines and already provides for a citizen. So she adds, when it is denied, the damage extends far beyond the immediate loss of livelihoods. It creates generational wounds of alienation that do not easily fade. Mr. Barata, we need to learn from our mistakes as a country. We need to learn as well from what happens when we have or pass laws that threaten that aspect of identity or of belonging to a country that we all call home. I was reminded recently, especially on that part of the power of the minister to be able to also determine who is a foreigner or not. Ellison here reminded me that in the 90s or something was a policy where the Nubians were stopped from having bank accounts also as a result of policy. Now, we must be careful of any laws that intend or want to define who a foreigner is away from what the Constitution has already done. Number three, that law essentially should regulate influence by disclosure before prohibition. If I, an individual, I am lobbying government, if I want government to be able to pass policies that will help the industries that I represent, I should not have any threat of criminal sanction for any of the work that I'm doing if I have disclosed specifically what I am doing. And so ultimately, what this law does, and this is one of the problems I have with it, is it creates an environment of suspicion. You know, everything is suspicious. Any money that comes into the country, as long as it's from a foreigner, is suspicious. Why are we being so suspicious? If you have that environment of disclosure where you know exactly what activities, and specifically, as I said, if you have already defined the mischief and you know the categories of people that you want to be able to disclose or to tell you exactly what they're doing, I feel that that would be a fair way or fairer way to be able to regulate and stop interference, because then people are disclosing, and if they don't disclose in that way, fine, that is after you, that is up to the government of Uganda to be able to go after them. Number four, one of the most important areas in this country, which for many of us that are in policy, we hope can continue to be respected or can be respected, is the civic space, the civic and engagement space. It is in a democracy, it is healthy for us to disagree. It is healthy for us to share with government what we don't agree with, without fear that we are going to be bundled into, a place somewhere because we have spoken out against a policy and how it should be. Now, this bill currently mixes advocacy, policy engagement, meetings, employment, public debate with hostile interference. A good bill should be able to separate them. If what you're trying to stop is hostile interference, then why are you looking at symposias and other things like that that are looking at other topics? If I want to advocate for a policy which I have gotten from another country, perhaps that gives free pads, menstrual pads to young girls, why should I have to seek the consent of the minister for me to be able to encourage our lawmakers to be able to pass policies and laws like that? So I feel how this law could be better is if it could separate civic space from national security offenses and make it clear these are the national security offenses that you will face should you decide to participate in them in that regard. But what it is doing and what it does is it creates a permissive way of life, a permissive way of us practicing our professions, where it turns that ordinary participation into something that should get permission. That cannot be constitutional. Number 5, remove prior permission of ordinary activity. Like I've already mentioned, if I go through all of the different clauses of this particular bill and how it affects several industries, and I hope we'll have time to be able to go through that. But why do I have to get permission, like I say, to be able to engage in policy? That, for me, is where we should be able to draw the line. If we're looking at foreign interference, let it be so. But as a Ugandan, as an advocate, I must have the right to practice my profession. I must have the confidence that I have attorney-client privilege in how I represent my clients without the need to be able to disclose to a minister or to a particular body every single instruction that I've gotten as long as I've received money from a foreigner. That, in effect, is what this law does. So I think if you read the Attorney General's piece and what you're sharing, you are right in saying that we need to protect our sovereignty. You are right in saying that these are issues that touch sovereignty and governance, but what the drafting of this law is not good. And that is really the short answer of it. And what it does is it subverts that aspect of sovereignty. I'm going to end on that part with also the disproportionate penalties. How do you find, for that particular provision that I have read to you, if I have a policy looking at, I am trying to advocate for menstrual pads, or I'm trying to advocate for the removal of mobile money tax, I risk, as an individual, a fine.
Omission-based judges.
Exactly. 100,000 currency points, or imprisonment for 10 years, or 20 years, or both. How can that be proportionate if I am looking at policy engagement? That seems very excessive. So I implore the Attorney General, being that, of course, ultimately, maybe that is the age-old discussion as to whether the Attorney General should be advising government or advising the people of Uganda. I feel in this instance, maybe that's what would call how in Parliament you have the leader of opposition. Maybe we also need a counter-AG who is looking at the interests of the people of Uganda and saying that as professionals, as industries, does this law actually do what it says or what it is intended to do, or does it actually cause more harm? So it could have been drafted very differently, and I even, for example, in Part 1, it could say the purpose of the act is to protect Uganda against covert foreign control, undisclosed political influence, unlawful foreign funding of electoral and government processes, and national security threats arising from a foreign direction or deception. If you're going to register, make sure that you remove or do not add, that if you're going to register anyone, it should apply to persons acting on behalf of a foreign principal in relation to certain criteria. Let's say if you're lobbying government or parliament, if you're funding electoral or party or political activity, if you have any strategic communications intended to influence public institutions on behalf of a foreign principal, or work relating to designated strategic assets or critical infrastructure where foreign control is relevant. But it should exclude, and that is the problem I have with it, because it bundles all of us together, ordinary Ugandans who are practicing their professions. It should exclude Ugandan citizens wherever they are resident. It should exclude remittances and family support. It should exclude legal representation and advocate-client engagements. It should exclude academic, journalistic, and research activity. It should exclude ordinary commercial trade, charitable religions and, it should exclude charitable, religious, and humanitarian activity, unless there's any prohibited conduct in that activity. It should exclude professional services in the ordinary course of business, And it should also exclude policy dialogue, symposiums, and technical assistance discussions where funding and participation has been openly disclosed. If it does not do that the way that it is, if I read the clauses, and I encourage every Ugandan to be able to read them, so that when you're responding or seeing what the Attorney General and what Mr. Barata are telling us, you're seeing that what is in their minds is very different from what the person who drafted this law actually did. If you're saying that what you're trying to do is to stop foreign interference, and then you have a clause like a clause 25, reporting of foreign funding. It says a supervised institution shall not pay out any money to an agent of a foreigner without the agent of a foreigner declaring the source of funds. And number 2, submitting proof of written authorization of the minister referred to in section 14 where applicable. If a bank or payment company does not do this, they risk a fine or imprisonment. Now, this particular clause 20, which by the way, I haven't heard many people talking about it, but this does not talk about any 400 million threshold. This clause 25 says that any money, as long as it is from a foreigner, and we've already been talking about the definition of a foreigner. So if a maid in Dubai or in Qatar who has gone to work is sending money to their mother back home, they are a foreigner. And the mother, in essence, has to go and declare the source of funds. If, as an advocate, I am representing any company that has foreign shareholding, I am, in essence, representing a foreigner, and I must be able to report. Again, I will give examples of the industries that we operate in where we work with foreigners on a day-to-day. Now, if you're telling me that every bank should be able to submit proof of written authorization as to what I am advising my clients, or as to what someone in the diaspora is remitting money to their relative, that I feel there's something not right with that. And that's why I'm saying that this bill has overreaching power. So what that is going to do, in essence, this clause that I have just read, is going to make it difficult for ordinary Ugandans to be able to continue to work. We already know that the banking sector is one that operates from a position of caution. Now, if you add other layers, it is going to become impossible for money to move within the economy, and it is already difficult. I keep reading in the papers and seeing how our lawmakers, our government is saying that we have reached middle income, or that there is money that is actually floating in the economy. But Mr. Barata, if you actually go ask ordinary Ugandans, even the lawyers, maybe even some that are in this room and beyond, if for them they have this money that is floating around, they will tell you that, even to be car, as they say, we are all just gumite, is it? But that is because there is less money that is in our economy. Now, if you continue to make it difficult for money to move, these have adverse effects, and it is going to become difficult for us to work. We are going to lose clients as advocates, and I'm going to give you practical examples of how clients have feared or are fearing, that if I'm going to come to Uganda, what is the investment climate like? Ultimately, when we're speaking to these clients, we are basically foreign service employees. I am supposed to tell a client the entire policy of Uganda in regards to investment and how it is. So how can I do that when I have a law like this that is essentially making it difficult for them to be able to invest in this country? So the law could be made better or more constitutional in those ways. And I do hope that the Land Attorney General and you, my friend, Sabarata, could be able to go back and say, look, can we first wait without passing this bill as it is? Can we first listen to all of these views? And then when we decide to pass it, we pass it in a way that gives that certainty as to what you intend, what the Attorney General has written and what you've mentioned. Because it is true, we have to stop these people from interfering with our sovereignty, but not in the way that you're proposing or you are saying or regulating under this bill.
If you're just joining us, I think we're now live on YouTube. Welcome to the Judicial Service Conversations. It is fair to say it's getting hot in here. Now, maybe just for clarity, Mr. Barata certainly is not, at least not to my knowledge, yes, one of the draftspeople of any law. Yes. As a private lawyer and as a volunteer in the NRM, he may not be the draftsman. But you know, Ken, you said a very interesting thing, and I remember the story. And maybe I'll hand over to Mr. Barata to respond very briefly. I remember the story of another country, which I'll not mention, where you said that you have to go to the minister for approval for your ideas. So there's a country, I'm just going to tell you the story, then Mr. Barata, you can respond, where a foreign lawyer who I have seen, and I only remember the story because I can see the guy here. The foreign lawyer was Ugandan, yes. And he was asked to go to a country, I will not say, a country not too far from here, to represent a big political opponent of the government. And he was told, you can represent. So after the accused was taken to the dock, cross-examination in chief, that means, for those who don't know, the prosecutor laid evidence against the accused, who was the politician. And then my friend, who I see here, stood up to ask questions. He said, no. For you, you're a foreigner. He said, yes. Now, for you, your questions, you must put them in writing. You give them to the prosecutor. After he reads the questions, the accused person, the witness, shall give you his answers 5 days from now in writing. So that and then if you have a follow-up, you also write. Then they write. So I think what Mr. Muhanji is fearing is that when he's organizing the KTS symposium, they shall ask him, write, give us the policy. After that, they will tell him, write again. And before he knows it, the symposium would have symposed.
So, thank you again, Ellison. And Kenneth makes a compelling argument. However, I see that from my perspective, there is an apprehension as to how enforcement would be. There is perhaps a bit of distrust, or a significant amount of distrust, on how the law would be implemented, or how it would be enforced, or how this regulation would be carried on day to day. Would there be delays occasioned to businesses? Because you're talking about money being more difficult to circulate, because you have to get to confirm, if you're a bank, that the foreign agent has gotten authorization, etc. And that is valid. There is that apprehension. But now, and there is a debate, and even to my mind, do you stop legislating because you are saying that we might have some weaknesses in the manner in which we tend to enforce laws? Do you stop legislating and say, we are very weak and inefficient, or we are perhaps even very corrupt as to how we go about enforcing these laws? So let us all together just stop legislating, and maybe one day we shall become more efficient and we shall start from there. I do not think that's the way to go. One of the key, in fact, the main issue in this bill is a term that maybe unluckily is also not defined, is what are foreign interests, especially foreign interests that are against the government policy or the interests of the sovereignty of Uganda. And that is the issue. So if obviously you are conducting a symposium, let me leave the symposium for now, because maybe that is a bit more complicated. If I am a commercial bank conducting business and I am a foreign company registered in Uganda, as we all know, a foreign company registered in Uganda, Ellison tells me that there are people who may not be conversant with these things. You can have a company which you simply start off here in Uganda and you register. You can also have a company that is registered elsewhere and you also register it here as a foreign company. But of course, you can also have a company that is principally a foreign company which is also registered in Uganda. But anyway, let's say there is a commercial bank operating in Uganda, and it is for all intents and purposes a foreign bank. It is conducting commercial banking. It is licensed to conduct commercial banking. it ordinarily reports on each and every transaction. In fact, the limits are even lower. I believe, is it still 20 million shillings for you to report daily? Every transaction, 20 million and above, you report it daily. So if it is a question of how you will enforce, of saying you are creating a further layer of reporting, that can be solved with regulation. But it is not to say that it is impossible and it will limit, because under AML we do this. Even lawyers,
AML being
anti-money laundering, sorry. Even the lawyers, we are already required to make these reports. I don't know, maybe there are some lawyers who don't, but we do. In fact, we are even required to register with the Financial Intelligence Authority. Right? So, if the argument is that you are creating a layer of bureaucracy, that is a different aspect and it can be addressed through regulation. If you are promoting something, for example, and I don't want to, I know it was simply an example, but let me just use it for now. If you are promoting a policy of having sanitary pads freely distributed to all girls in primary school, for example, I mean, certainly that is, it could be foreign interest, but is it against the sovereignty of Uganda? No, it is not against. It is not against. If you're promoting mission-based judges to get rid of the backlog in our courts and therefore to provide more efficient justice to our citizens, is that against the interest of the sovereignty of Uganda? No, it is not. But if, on the other hand, you are saying, I am going to supply sanitary pads to all the women of Uganda in exchange, and I am going to ask them, in exchange for them organizing riots with the intent to overthrow the constitutional order of Uganda, you are acting against the interests of the sovereignty of the people of Uganda. It is just like in elections, which we have just been through. During the election campaign, you're not even allowed by law. It used not to be in the law, now it is in the law, to even make a contribution at a fundraising, for example, at a school or at a church. Why? Because there is a risk, and it is more likely that you are going to trade your contribution for a vote. So that is prohibited. So the foreign influence is there. Now, if it is a question of saying, oh, this just makes it a bit more difficult for us, we must contend with these difficulties. And that is, unfortunately, the hard reality is that some of these difficulties we must contend with if it is simply a question of dealing with bureaucracy. Now, let's get back to constitutional freedoms and civic rights and so on and so forth. And this is not the first time I've had it. I have had arguments saying that I think people have been saying, oh, why are you making this bill? Because sovereignty belongs to the people of Uganda. We are the sovereign people. And I think that is a misunderstanding of the problem. The other one I have heard is saying, you will no longer be able to send your mother money. But as I have said, one of the things that we are establishing here is a principal-agent relationship. If you are sending some money to your ill wife or mother or relative to pay for their medical bills, how is that influencing foreign policy? How do you become an agent of a foreigner when you yourself, is it your mother who is your agent? What are you doing? Foreign policy. How do you become an agent of a foreigner when you yourself, is it your mother who is your agent? What are you doing? So it is a bit more extensive, because if we start going into the definitions, what creates an agent, and I know there are some the definition seems wide. Let me see where it is. But so that one is clearly excluded. if you are dealing in pure commercial interests, where you have disclosed these are the owners, these are the shareholders, this is where we're investing our money, and this is what we are doing with it, then you have no problem. Mr. Kenneth did say that why don't you let people disclose voluntarily? But this is exactly what the bill is proposing. The bill is saying you are a foreign agent, and that is why the definitions are important. You are a foreigner, or you are agent of a foreigner.
Isn't the definition, isn't that term traumatizing?
Now, that is that is where the crux of the matter is, because it is that definition that then tells you that, okay, we have identified you as a foreigner or an agent of a foreigner. Now, please, go and register voluntarily. Obviously, when you register, it is voluntary registration. These are my activities in Uganda. This is how I fund them, or this is how I do my communication around my activities, and we carry on. Now, the issue, the penalties kick in when one of two things happens. Either you conduct adverse activities. This is what they have called, I think, disruptive activities. You had registered, but you conduct adverse activities, or you did not register and you are conducting adverse activities. Then we got the penalties. Now, as to whether the penalties are too heavy or too light, how many currency points? 20,000 currency points. If that is too harsh a punishment, well, that is a matter for the legislature, and can debate and say this punishment is too harsh for this offense, let us reduce it. So for me, what I am saying essentially is the bill addresses valid concerns substantially, in substance. Are there areas where the drafting might be improved? Certainly. Are there areas where certain things, like, for example, penalties, can be adjusted? Certainly. But we do agree that the bill is necessary, or at least, at the very least, it is important that we have a law that puts in place a framework to protect our sovereignty from adverse foreign influence. And that is the crux of the matter. I do not agree that this bill stifles debate. It does not. What this bill will stifle is a deliberate campaign that undermines the sovereignty of Uganda. Okay? So, if, like, I don't know which example to give, because all these examples are seemingly controversial and have never been, have never gone beyond civic debate, many of them. If, for example, you are based in, for hypothetical reasons, let's just say you are based in some island somewhere in the Indian Ocean, and you say, for me, I support the colonization of Uganda, and you begin a campaign to mobilize people to say that Uganda should be recolonized, and you even start funding people here, and you are a Ugandan citizen, let's say in the Comoros Islands, and you, a citizen of Uganda, undermining the sovereignty of Uganda, how then should the definition capture you? And this is why I much prefer the definition of the U.S. Foreign Agents Registration Act, which says any person, except if he is a citizen and domiciled in the United States. So it captures everybody, citizen or no citizen. The exception is if you are a citizen domiciled in the United States. This is pretty much what we have in the bill. The only difference with this bill is it has split that definition into things. And maybe the area where I agree more entirely with both Kenneth and Ellison, I believe, is perhaps the wider powers of the minister to determine. I think something as important as the definition of who a foreigner is and who an agent is must be concluded in the primary act and not left to the minister. That on that part I do agree entirely. So ultimately, for me, what we are debating is a question of, and this is where perhaps the legislature should come in, how can this bill be adjusted in terms of its language, in terms of its outlook, so that when it is debated, I don't know whether it is the second reading or what. I know they have public hearings on Thursday and Friday, right? That at the end, when it comes up, when the committee comes back to report to Parliament, it presents a bill that addresses the substance and that addresses the concerns that have been raised, the genuine concerns that have been raised by the people. Of course, there are other concerns that really are neither here nor there. There are people who are just saying, this is rubbish, just throw it away, this is dishonest, and so on and so forth. But those I don't pay very much attention to. I rather much pay attention to Kenneth, who has a solid proposal on what to do. For as a by the way, I also, while I am also, Ellison did mention that I do not draft, and I have not drafted any bills. I am also not in charge of the calendar of Parliament, and I have not say in what comes up on the order paper, when or why. So that, I think, is my view. I don't know if from my perspective we actually seem to be really on the same page, because I think what we are discussing is the drafting and so on and so forth, rather than the substance and the objective of the bill. Thank you.
Okay, if you're just joining us, welcome to the Judicial Service Conversations. We are having a debate here on sovereignty, foreign influence, and constitutional limits. We are discussing the sovereignty bill, and we are discussing we're discussing the sovereignty bill. And I think I'll hand over to Mr. Alfred Muyaka. Right now, Ken and Enoch. Alfred here is a very senior lawyer. Among young lawyers, he's the deputy. I keep saying he's the Deputy Secretary General of the East African Law Society, representing the young lawyers of East Africa, and he's the only person who has been elected during the tenure of the Radical New Bar, because the rest of us have been injuncted. But Alfred, somehow, I don't know what he did. He got himself elected. So, Alfred, over to you. We have a number of questions from the audience and a number of comments, and we shall be, I think, sharing those with you right now. The debate is actually very engaged online, and people have a lot of things that they are saying. Over to you, Alfred.
Thank you, the lawyer's lawyer. As you have said, the debate is online. Is very many questions coming on board. And I have a comment from Anthony Natif is saying that Mr. Barata is... Actually, this should be a question which you should answer. He says, Anthony Natif is saying that it's clear you're not comfortable with certain aspects of the bill, and saying that you head the legal department of NRM, which has the largest numbers in Parliament. What would be your advice to them in the areas which they should push back when they are debating the bill? And then this should go to Mr. Kenneth, because Anthony still says that Mr. Barata is defending the use of a hammer to kill a mosquito. and he still, as Mr. Enoch submitted, that he agrees with the bill, but it has certain provisions which are problematic in nature. And then from the corner of Mr. Kenneth, who disagrees with the bill as bad, is asking which particular provision is cross the constitutional line, and most clearly, and why. We need to go through them for the audience to understand those particular provisions. So I think I'll start with Mr. Kenneth, then we can get to Mr. Barata. Thank you.
Okay. Thank you very much for those questions. Edison, I also add my my voice to what you mentioned. We all don't know how Alfred here got elected when other people have been in abeyance for such a long time. But congratulations to Alfred. I was also among the people that put up my hand for you. So well done with what you're doing. So let's. I may be a tech lawyer, but I am very analog with how I do my preparation. So if you're watching online, I have like all of my papers and everything here because I really wanted us to have a very serious discussion. I agree 100% with what Natif is saying, using a hammer to crush a mosquito. And here I recall as a teenager, I was quite stubborn. And well, mostly as a teenager. And I remember I received a lot of chiboko from my father and from my teachers at school. But I recall there is one meeting I had with a teacher. I think he was even just asking me certain questions, but because that time I had received maybe like 50 or something chiboko, I knew that every time I see this man, I would get chiboko. So he calls me into the room, and in the room he has a chiboko just right next to him, and he's trying to talk to me about a topic even unrelated to that. But as you can imagine, for me, the whole time what I was focusing on was a chiboko, because it was what I was used to, that this man is going to. So this is really the same thing here. We have a bill which is unconstitutional in many respects, and which we are saying we agree with you in regards to protecting our sovereignty, but is this bill necessary? You know, our attention is only focused on all of these provisions that make it difficult for us to be able to carry out our work, and we forget what the intention of the bill is, and you've eloquently put that intention forward. But like we said, it really needs to change in many respects. But let's look at which particular aspects of the Constitution it offends. Let's start with the definition. Number one, all of those people that are using that example of an ordinary Ugandan who are made with sending money to their mother or to their relative, or someone is sending money for construction. Under clause 1, agent of a foreigner, it defines an agent of a foreigner to mean a person who acts as an agent, representative, employee, or servant, or any person who acts in any other capacity at the order, request, or under the direction or control of a foreigner, or of a person any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized by a foreigner. Now, what that says in short is that you are an agent if you are controlled or financed by a foreigner, right? The same interpretation section that clause 1 also then, like we said, defines a foreigner to include a non-Ugandan citizen.
By the way, not if you are financed, if you act,
But
represent, are employed by or servant of a foreigner.
It is, and it adds
Actually,
under
the only word there that I see that might be problematic is subsidized.
well, if you read
but the rest of it, I think is very, very clear agency. Yeah, I do not see this is ordinary agency.
Indeed, but you see, it says that any person who is controlled, financed by a foreigner. And as I'm saying, when you look at the definition of a foreigner, it includes a non-Ugandan citizen, a Ugandan citizen residing outside of Uganda, an international, multinational organization, or any person, institution, or body that the minister may, by statutory instrument, declare to be a foreigner. Now, when you go to clause 14, you will agree with me, Enoch, that when you read that part, it means that if someone is actually residing outside Uganda and they send money to a Ugandan or someone within Uganda, they become an agent. That person who has received money or control becomes an agent of a foreigner. By the definition here.
Sorry?
If someone is in the borders of Uganda, a Ugandan, and they receive any finance from a foreigner, they become an agent.
No.
But that is what it says.
I don't know. Which are you reading section?
I am reading, and I'll read it again. An agent of a foreigner means a person who acts as an agent, representative, employee, or servant, or any person who acts in any other capacity at the order, request, or under the direction or control of a foreigner, any of whose activities are directly or indirectly controlled, financed, or subsidized, subsidized by a foreigner. It is anyone who falls within this category. And if I then go to clause 14, which makes it mandatory for every person that you shall not act as an agent of a foreigner unless you are registered with a department and issued with a certificate of registration by a minister. So if that mother, father, whoever is receiving money from that foreigner, a Ugandan who is a foreigner, that person is liable on conviction to a fine not exceeding 50,000 currency points or imprisonment not exceeding 10 years or both.
How much is 50,000 currency points?
But also,
Let us first calculate before you
but
come in
also, what
anymore.
are they receiving that money for?
You see, that is each currency point is 20,000. So it's 20,000 times 50,000. That's 1 billion. That is the fine for you receiving $10 or $20 from someone and you have not registered. Whether, you see, Enoch, and this is what I hope you can be able to appreciate. Your mind is that it is impractical for me to assume that a maid who is sending money or someone who is doing cheyo outside of Uganda to their parent for any reason is not covered under this act. You are right to assume that it is absurd that something like that can happen. But the way that this law is drafted is such that it covers those people. And they will be fined. Whether you enforce it or not is another matter. Like that story I told you, the end of that story is I was never caned by that teacher. He just wanted to find out how I was. But the entire time I was focused on his cane because it was there. And this is in the law that they have to
cane.
register. Yes, this is the cane. So whether you want to apply it selectively or not, that is the preserve of government. I cannot get into the mind of government as to who it wants to prosecute or not. But the fact that we have it in our law, that an ordinary Ugandan has to register with a minister and without it they risk conviction, that is a problem and that is unconstitutional. Let me move on to the other provisions that I feel are unconstitutional. Of course, we've already looked at...
Maybe before you move on, maybe you could just do a quick rejoinder on that.
Yes, I actually don't agree with that interpretation. Perhaps that's the problem. I actually don't agree with that interpretation, and perhaps that is where the challenge starts. I think the definition of agent of a foreigner is very clear. There has to be agency. And at law, we know what agency is. You are executing roles or duties or performing certain actions not for yourself, but for another person, and upon their direction, upon their supervision. It is these are the words used here. So if just hold on, just exactly agent, your agent, and I think this is overemphasis, representative or employee or servant. So when you continuously use the example of a maid sending money for the treatment of the mother, I think that is a misrepresentation of the issue. If, however, this maid is involved in subversive activities and has engaged the mother to be a helper in those subversive activities, yes, they will become an agent of a foreigner. Now, where I also agree with you is in the one something F, where you're where you're defining a foreigner. The F, where a person or institutional body, the minister may by such an instrument declare a foreigner. I do agree with you, and to answer Tony Natif, this is one of the areas where I would say, no, you conclude this issue of the definition once and for all, and we conclude it so that it is clear, instead of leaving it hanging so that anybody can be defined. That is one of the areas, certainly, that I would change. But I do not agree that ordinary people who are not in a principal-agent relationship are covered in this situation.
Maybe we'll. I think we have about 12 minutes left. Enoch, I think you can give us 12 minutes of your time.
Oh, yes.
Yeah.
I didn't know time had rushed.
We have about 12 minutes left. And I want to come back to the points you're making. But before we can come back to the points you're making, allow me to hand over to Mercy Makabai Chemutai. She's also one of the young lawyers. Although she hasn't been elected anything, but she's one of the hosts of the Judicial Service conversations. If you're just joining us, we're having a debate. Of course, we are now stuck on the definitions, principal and agent. You know, when you talk about 1F, there's a provision in the regulations, I think, which we all agreed in the bill, that the minister by statutory instrument can designate you a foreigner. So the fellow, if you made my friend Ken Mijira here, if you made him Minister of Internal Affairs on 12th May, he will go around with a patch of documents. Whoever scratches his car, he shall designate them a foreigner. Over to you, Mercy.
Thank you, Ellison. Thank you, Mr. Barrett, and thank you very much, Kenneth. I think we're having a very interesting and educative conversation, and I know that a number of people in our space are following intently and have so many questions. I hope we can be able to go through them. I'm going to just direct two questions, one to Kenneth and one to Mr. Barata. Just building on the previous discussion on the penalties and the requirements to register. I know we've had a lot of our clients approach us wondering how this, a number of them being multinational corporations really, wondering how this law is going to affect their business. And when you look at this particular law, you're creating a scenario whereby if I'm receiving a certain amount of money within a particular year, I must register with the Ministry of Internal Affairs under this Security and Peace Department. That's the bottom line of it for our business investor. Now, we already have the BO forms that we use that declare our beneficial owners. That information is publicly available at the Uganda Registration of Services Bureau. Why isn't that enough? If we're dealing with a company that has come and properly registered itself here in Uganda, it has declared its beneficial owners, its intent and the business it's doing over the years, for instance, is very clear. Why must we include another regulatory step, which is to now register and annually renew that registration? And actually, when you look at one of the qualifications, which was interesting for me, was the fit and proper person test. There's no definition on what amounts to a fit and, I mean, the guy can wake up one day and say, you're not a fit and 400 million in a year. Look at clients who get 1 billion for one transaction, and they get money. Let's look at petrol stations. They're acquiring numerous petrol stations. They're receiving this money from another country. This business has been happening over the last 20 years. How is this law not curtailing their business? I'm struggling to advise clients, for instance, to show them that this particular law is not curtailing their business, because on the face of it, it actually is. And it's creating, and there is a case for the implementation part and all those things, but truly when you look at a number of these clients, as Ken had highlighted, they ask for an overview of doing business in Uganda. Let's just make it as simple as that. And then doing business in Uganda now actually involves another regulatory step once the sovereignty bill is passed, which is you must register with the Ministry of Internal Affairs under this department, and you must make sure that any money you receive at the bank, before you get that money, you must get a written authorization from the minister. And this is not just indicating your source of funding, because source of funding is something that is already happening, but getting a written authorization every time you need to access your money to buy an asset or to manage the operations of your company is really going into my my house. Like, you literally want me to, and I don't want to say undress as a business. You want me to undress myself and tell you this is what I get, this is where I take it. I mean, I think that the BO form already caters the issue of knowing who is behind the business and what they're doing. But I'm happy to hear your thoughts.
BO form, you mean beneficial owners form at Uganda Registration Services Bureau?
Yes, the beneficial ownership form is subject to the law that was recently passed, I think 2022, which required every company, foreign, subsidiary companies and locally owned companies, to declare who their ultimate beneficial owners are, who are the natural persons, who is the human being behind each entity. If I have filed that form at the Uganda Registration of Services Bureau, and every time a bank requires you to open an account, or for annually you're supposed to update your KYC documentation, and that KYC documentation includes your
KYC means know your customer.
Yeah, know your customer, your beneficial ownership information. You've submitted your MEMATs, your BO form, all that documentation. At that stage, haven't I satisfied this test as a company that wants to invest in Uganda? And how is this law not curtailing business, really, in your opinion?
So that's to Mr. Barata.
Yes, and then to Ken, my question to you is just to give, for the people who are in the space, a walkthrough on what will happen if this law is passed. What will happen to businesses that are in operation and those that intend to come into operation in Uganda, just from your perspective, an unbiased opinion on that.
Okay, maybe just 2 minutes each, gentlemen. We are running out of time.
Thank you, Ellison. I did mention earlier, and this is just to be very, very specific to the question asked, the KYC and the know your customer requirements and the beneficial ownership requirements, etc. On that aspect, that is why I said I would rather match the approach taken by, for example, Uganda Bankers Association, which talks about even the limits on the amount of money we're talking about, because I think they talked about 400 million and so on and so forth. And my argument is simply this, that yes, these are bureaucratic layers, but they do not digress from the substance of the principle. And as long as they are bureaucratic layers, they can be adjusted. Even that figure can be adjusted, same way that the penalty can be adjusted downwards and this minimum figure adjusted upwards. I do not see where the challenge is from, for example, the point of view of the reporting entity. Because as I have said, yes, and this is the challenge, and it works both ways. You can't say that you have been reporting transactions 20 million daily and you will fail to report 1 billion shillings. Okay? It is unlikely that you will fail to report that money. So for me, it is a question of implementation and how will this and the fear, as Kenneth,
tactics, not
yes,
strategy.
Exactly, and as Kenneth quite clearly puts it, there is more apprehension because maybe of a lack of trust or something. There is more apprehension than the actual thing happening, which is not there. So it is an apprehension of how the enforcement will happen, and it is not a question of the principle being bad. The principle is correct and the substance is correct. These other things can be adjusted. Now, the business, if you are saying the beneficial owners, yes, this beneficial owners clause is in several laws, the companies law, the cooperatives, and so on and so forth. But there are other entities that don't fall in there. That's number one. Two, knowing the beneficial owners is one thing. Knowing what activities they are dealing with is another. Because we are talking about covert interference. So there must be because right now many of these beneficial for example, a company, a normal company, you do your beneficial ownership, you do your know your customer, and then you do your accounts, which may or may not be audited by URA depending on how your tax compliance is, and you file some in the company registry and so on and so forth. But this one is specific. It is looking for, URA will look for tax issues, and the registry of companies will look for other issues. This one is dealing with, can we verify, and it is specific to the foreign agents and foreigners. Can we verify that all your activities here are above board?
There's a guy here
Right?
with a question. Let me just ask. Let me
Yes.
just throw this question to you very quickly. There's a guy who has asked that if he sends money to his girlfriend
Yes.
to construct a house, and therefore she's his agent, he's abroad, she's his girlfriend. Ordinarily, she would have been his agent. Maybe intimate. Ordinarily, she would have been his agent. He sends money. He's not said the girlfriend. He's used maid, but I've seen someone else here who has this problem. So if he sends this money to his girlfriend, does his girlfriend become? If he's a Ugandan living in the diaspora and he has a girlfriend here and he sends her money to construct a house where he's the ultimate beneficiary, does she become an agent under this law?
Yes.
I think that's the question he's asking.
Yes.
This is
The straight answer would be yes. The straight answer would be yes. And then the question would be,
I think he's happy with that.
the straight answer would be yes. And this is the point, that this person will receive this money, right? And now it goes back down again to that enforcement and maybe a layer of bureaucracy in the system. But this is where it goes. Yes. So we say, yes, you are receiving this money. Are we sure that you have put it to the house? Or are you disguising it as going to a house while it is going to ADF? So these are some of the challenges. And as I said, some of these things are complicated and we must bear with the complications.
Yes, Enoch, I used to just really wanted to weigh in there. I wish there was any provision in this particular bill that actually mentioned exactly what you have said, that there is that perhaps someone has sent money for this purpose when it is supposed to be for another purpose. There is nowhere in this bill that actually provides that, and yet that is the intention that government has in being able to provide this bill. And that's where we are saying that.
And if I can just interrupt you, someone called Principal D, I think, is making that point on Twitter as well, that the covert interference is not in the bill.
Yeah, indeed. And so if you're saying that this bill is meant to regulate or to stop covert interference, be clear is what we are saying. Otherwise, you're going to end up affecting many industries or sectors. And so I'll just rush through the different articles that we feel this offends. Article 29, which is on the freedom of speech. If I already gave
Those
you
articles of the Constitution of Uganda.
Yes, sir. Yeah, these articles of the Constitution of Uganda, which guarantees freedom of speech and participation as well in the policy environment in a country. That's under Article 43. So all of those, if I'm supposed to get permission from a minister, if I cannot be able to give comments on policy, that we feel offends the Constitution. Article 20, which guarantees fundamental rights of Ugandans. As we all know, constitutional freedom cannot be a licensed privilege. So what it is telling me is that for me to be an advocate, for me to be a policy lawyer, I must be licensed before I am able to do that. Yes, I am licensed, but not licensed.
You're licensed.
You're
saying you're licensed even now.
Yes, I am a licensed. Yes, I am a licensed advocate for purposes.
You cannot practice law without your license.
Yes, but I don't need to be.
Even if we know that you have practiced for the last, 15 years or 20 years, you can now, if you not renew your license this year, you will not practice.
And that is true, but I don't need a law degree to influence policy. I don't need a law degree to talk about a particular policy that affects me.
And that's the point.
And I'm saying that because this law says that the only way I can be able to contribute to policy is with the permission of the minister, that is unconstitutional. That offends a fundamental right and essentially takes away that constitutional freedom and makes it one that is no longer something I'm entitled to, but rather something that I should be licensed to do. Then, of course, if you also look at Article 21 of the Constitution as well, too, which looks at equality and freedom from discrimination, already what we've been talking about, foreigners, that is definitely discrimination. Article 27 on the right to privacy, when it comes to me disclosing all of these things, even for other things that may not have those aspects of covert interference. That's if you're looking at clause 21, 25, and 26 of this bill that requires us to be able to disclose all of this information. Article 28 is actually the one for any legal mind or jurist that carries a lot of problems of the Constitution, which looks at that, if I was to read for you Article 28 of the Constitution, Article 28:12, it provides that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. There has to be some certainty when it comes to when it comes to illegality. If I am doing something disruptive or subversive, if I have a clause like the one that we have here that says that the act applies to an agent of a foreigner who influences the public to oppose the policy of government, how can that be criminalized? What you're saying in essence is that we should not talk about any of the policies of government. It is criminal. If you're saying that I should not influence the development of policy of government without the consent of the minister, that, like we're saying, is very unconstitutional. And by the way, if I also look at Article 43(2)(c) of the Constitution, which looks at public interest, that anything in the interest of the public, something like national security, which I think is the real reason why we have a bill like this, but it shall not, that article, public interest shall not permit limitation of enjoyment of rights beyond what is acceptable and demonstrably justifiable in a free and democratic society. That word, demonstrably, you gave an example of someone being on an island and trying to be recolonized. I know it was just an example, but I also feel that every single thing that has been added as part of the scope or mandate of this act, whether intentionally or unintentionally, is one that goes beyond that scope. And essentially, there is no it is not demonstrably justifiable for us to be able to have this law. Specifically, if you're talking about reporting, why don't we amend the Anti-Money Laundering Act? What is the problem with it? Which says that if you have any, like what you're saying, if you have 20 million, then you receive 100 million, the AML law will come in. We already have the Political Organizations Act, which makes it so that it limits political donations, or especially from foreigners. We have so many other laws that would look at, or that would be able to protect the sovereignty rather than the bill or law as it is. So I'll end with this, the effect on the different industries. One of the new industries that we have at the moment is the carbon markets industry, which relies on what we call carbon finance. As you rightly put, Uganda is a signatory to many conventions internationally. One of them is the Paris Agreement, which makes it so that Uganda has committed to join the rest of the world in talking about, or in being intentional about, this climate change issue. We have seen climate change has affected Uganda as a whole. So one of the recommendations of this Paris Agreement is that governments should regulate what they call carbon markets, voluntary and on the government side. But at the moment, all of the buyers of these carbon credits, so maybe essentially, I don't know if you can post a few things for people to be able to understand these things, because it may be difficult for us to define everything. But if I am selling a carbon credit, which as a result of planting trees, as a result of saving the environment, most of the buyers, or all the buyers at the moment, are foreigners, as far as this act says. All of that financing comes from that, from that side. Already, many of these people are complaining that they are not receiving letters of authorization or licenses. Now you come here with more things, more hurdles for them to jump. What would encourage them to continue to invest in Uganda? And Enoch, these are the realities that we're facing. I am a practitioner. I represent many of these clients, and it's becoming difficult for me to encourage them to come and invest in Uganda. They're asking, why don't we invest in Kenya or in Tanzania or in Rwanda or in other countries where it is easy for them to be able to invest and put the money that they want to be able to invest. Digital trade, telecoms, banking, we rely. I was looking at the Uganda Communications Commission report, which was saying that at the moment, I think we have about 35.6 million mobile money subscribers. We rely very heavily on fintech, on tech that way. The National Planning Authority also issued a report saying that our GDP grew by 6% 2023-24, but the services sector contributed the largest at 43%. Now, most of the entities in the services sector are foreign owned. And all of these now have an additional layer, or will have an additional layer of bureaucracy, making it difficult for them to be able to move money and make payments. I am part of several associations, and all of them, outside of UBA, we also have FITSPA, as I mentioned, the Financial Technology Service Providers Association is all fintech companies, Internet Service Providers Association of Uganda, all ISPs in Uganda, Alliance for Digital Trade, E-Mobility and Couriers, the Carbon Markets Association, all of these are saying that we interact with foreigners. If this bill passes as it is, it's going to be difficult for us to continue to carry out or to invest and have investment in the country. So, Mr. Barata, these are serious issues. You know, especially if you're asking for us who are also advocating for our clients to be able to have policies, that there are many policies that have affected business. Look at the mobile money law. I was looking at a UNCDF report, which again I will be able to share perhaps with...
UNCDF is?
Oh, the United Nations Capital Development Fund, which has some research, or carried out some research on the effect of mobile money. And I'll just read for you something small report. I will share it so that it will be available. The report provided indicative evidence from several interviews that the burden of the 0.5% tax on mobile money withdrawals has been disproportionately felt by some of the poorest people. Now, when these laws are passed with the mind that it is okay, we are going to amend even beyond years, it should be time immemorial. These are things we learned when we're learning legislative drafting. So a law like the mobile money one, we only found out the effect of it, and it is still continuing after that law has been passed. That cannot be how we create policies in Uganda. We should not create policies that will affect people first, and then we go back and try to amend. Because the reality, like I just mentioned, if you have lawyers now that are already struggling, speaking for lawyers, already struggling with work, there are fewer clients to go around. There are fewer sectors for clients to be able to represent. Now, if we're encouraging lawyers to be able to get into sustainability, to get into technology, but where are those clients going to? Where will they find those clients if all of those investors are actually scared? Because you're talking about fear. Yes, fear is a real issue when it comes to economics, when it comes to economy, and it should be taken seriously that any law that is passed must have certainty for the investors, and in the absence of that, that is not a law that should pass. So I really encourage the lawmakers, like you're saying, to go back and not pass this law as it is, because it has adverse effects on several sectors should it continue or should it pass the way that it is.
Enoch, we give you the last one.
Yes, thank you again. It's a pleasure being here. Time has run rather quickly. What I can conclude by saying is that we agree that the sovereignty of Uganda must be protected against adverse foreign influence, and to that extent the law is necessary for that protection. We do also agree that while Parliament is legislating, or at least that is my position, that while Parliament is legislating, it should iron out a few of these hitches that are there, rather than throw out the entire bill and lose it. Because, as I have argued before, it is important that we move forward progressively, and it is important that we address issues regarding our protection urgently. What is needed, though, yes, those hitches can be corrected, and perhaps Parliament can ask the proposing ministry to suggest how they will actually implement, in other words, how they will reduce this bureaucratic delay, etc. But I do not think that a fear of bureaucratic delay itself should deny us the protection. I would rather have a bureaucratic delay than concede my sovereignty. Thank you.
Maybe one last question, if you have time for one last question. Gentleman is saying, okay, for him, he's a communist and supporter of the Chinese Communist Party and an honorary member of the Chinese Communist Party. And in fact, he wants Uganda to follow the example of China and if maybe Singapore. And every day he gets up, he has his donors in China and they are making him support China. And he wants to come here and say, we must go the Chinese way. It is even good for our relationship with China. His question to me and to you, is he exercising his constitutional right to free expression and free association, to associate with foreigners and to speak what foreigners want to hear? Is it his right? And why should that right of his
It is
be regulated?
absolutely his right. And what the bill proposes is that you exercise this right within a regulated framework. But it is absolutely your right, and that right is taken away. Is not taken away, rather. Is not taken away. So it is absolutely your right. In fact, you can come and advance this policy and argue that you want Uganda to become a communist country. Perfectly fine. But under this framework, register yourself, declare yourself, say this is what I am here for, and then go ahead and do it. Okay? Thank you very much.
Would you allow me just also answer his question quickly?
Yes.
I would urge that person to read clause 5,
Of?
sovereignty of the people, of this bill, of the protection of sovereignty bill. It says under clause 5.3, a person shall not engage in any activity that promotes the interests of a foreigner against the interests of Uganda.
Yes.
If you promote the interests of a foreigner against the interests of Uganda, you commit an offense and you will be fined 100,000 currency points. 100,000 currency points is 2 billion. Huh? Yes, it's 2 billion, or imprisonment for a term not exceeding 20 years. So I would encourage that gentleman that once this bill is law, please do not want to speak about China.
No, there's a difference. There's a difference. Are you saying let us copy the system in China, or are you saying let us submit ourselves to China? Those are two different issues. If you are saying let us submit ourselves to China and we hand over everything to China and they manage us under their communist or whatever it is system, then obviously you're going to offend the law. If on the other hand you are saying I want to promote this, and you come and you say I want to promote this and I am being aided in my promotion by I have friendly people who want to spread their evangelism. Yeah. Go
By the
ahead.
way, on the day,
Connected to Ken Copeland's church.
on the day that the minister,
I'm not familiar with Ken Copeland.
on the day that the minister is in office, that's how he's going to be he or she is going to be considering your application, thinking, is it this or that, because of the powers that this law gives that minister on the days that the minister goes to office. Anyway, go on.
There are many questions, and I know we have many questions, and I know that Enoch has to be somewhere at 10 minutes ago.
Yes. Yes.
So I don't know if you have space for one more, or if we
I think I should be released because
I think Enoch has to run, and also we've overrun our time. But I'll give you one question, both of you. One question, rapid fire question. We do this as we conclude the Judicial Service conversations. And because of time, I'll just limit it to one thing. What book are you reading? What book, Mr. Barata, would you recommend to our young people to read and learn? People may not know, and we shall have time to have both of you back here in your individual rights, because the stories of both of these lawyers are incredibly powerful stories and with great experience. So what book are you reading that you would encourage our listeners to read? Mr. Barata and then Ken.
At the moment, I'm reading a book on...
You're muted.
Oh. Sorry, I'm reading right now about the different styles of leadership. I forget the author. Galloway or somebody like that, a lady. Yeah, Scott Galloway. So that is what I'm reading at the moment, and I would encourage it. It gives you it's more leadership, more in the sense of organizational leadership rather than political leadership.
Well, I will encourage our listeners and readers to read this book, Identity. This is by Lost in History, Found in Purpose, as Mahani said, just to give you context as to this question of identity, and it also teaches a lot about what it means to be a citizen. But if things are tight the way they are, and you're stressed the way that we all are, I am also reading another book called, it's a trilogy called Before the Coffee Gets Cold, by a Japanese author. I forget his name, but there are two: Before the Coffee Gets Cold, Tales from the Cafe, and I forget the title of the third one, Before My Memory Fades. It's a very interesting concept about time travel and being able to go back in time, and what things would you change if you are given the opportunity to do that. So if you want to distress and unwind away from this sovereignty bill, I encourage you to read books like that that will expand your mind and take you into a fictional world. Thank you.
And just for the record, we launched that book on identity right here on the Judicial Service Conversations with Asmani Saad. If you've been listening to us, I'm sorry we have to wind up. We'll have another debate tomorrow, and we shall be announcing who will be coming on that debate tomorrow. What I can say though, fantastic conversation. I will not give a long closing speech except to say that debate is good because the friction of different ideas creates heat, but it also creates light. It shows us where we are going, it shows us where we are moving. And now that you're both here, senior lawyers, and we are closing, I would have given you the option of a song, but you will allow me to impose on you a song of the parliament of the lawyers that they have always dedicated to me. And as we are winding up, I'm going to give a song that's always dedicated to me. But before that, gentlemen, you will forgive me. Allow me to tell you that the DJ is getting the song now. Just so you know, we have a resident DJ, and the resident DJ is Mr. Muyaka.
He has a resident song.
And there's a song we were going to ask you actually to propose the song, but since you're two, we decided that I will propose the song. And my DJ somehow, I don't know what has happened to the DJ equipment today. But maybe Mr. Segawa can assist if you have a way we can get this song.
Alfred have a DJ name?
Yes, Alfred has a DJ name, Young Lawyer.
DJ Young Lawyer.
Alfred's DJ name is Young Lawyer. Alfred is an incredible young lawyer. We have we were unable to have some other hosts like Joy and others, but I also want to salute right here in the audience. We have here Mr. Ken Mujira. Mr. Mujira is, for those who don't know, is the vice chairman or vice president of the Lawyers League. He plays soccer. He's a fit man. Now, the song we are going to sing is about me and entirely about me. It's an Afrigo song.
Why?
And to members of the law,
Why did I suspect that?
yes, because
this is a real apprehension,
right?
Yes, as you know, people have been saying when the coffee gets cold. For many of us in the law society, we have been waiting for this election. The coffee may have gotten cold, but I'll tell you this: you are now all agents. And you are going to listen to the song of the principal.
Thank you, Wilson. Are we done?